June 2nd, 1961. A pool hall in Panama City, Florida is robbed of $5 in change, beer, and soda. Clarence Gideon is caught walking around the street a few hours later with pockets full of change and carrying wine. Henry Cook accuses and charges Gideon with breaking and entering and robbery. Clarence Gideon, a 51-year-old dirt-poor electrician, is arrested in a tavern a few hours later and is brought to a Florida court. As an indignant, he is unable to provide legal representation to himself, requesting the court provide him with it under the Sixth Amendment. Because of a previous case, Betts v. Brady, where a court ruled that whether or not a lawyer was required depended on the circumstances of each case, the court denies him counsel because it was a non-capital case. Gideon is convicted and sentenced to 5 years in prison. From his prison cell at Florida State Prison, making use of the prison library and writing in pencil on a prison stationery, Gideon filed a habeas corpus petition to Florida Supreme Court against the Secretary to the Florida Department of Corrections, Louis L. Wainwright, by claiming his conviction was unconstitutional because of a due process violation due to his lack of counsel. The Florida court denied it, and subsequently, Gideon sends his petition to the United States Supreme Court, who reviews his case in 1963 and assigns him Abe Fortas, who would later become a Supreme Court justice. The issue at hand was, did the state court's failure to appoint counsel for Gideon violate his right to a fair trial and due process of law as protected by the 6th and 14th Amendments?
In a unanimous opinion, the court held that Gideon had a right to be represented by a court-appointed attorney and, in doing so, overruled its 1942 decision of Betts v. Brady. As Abe Fortas argued,
the Sixth Amendment promises that the accused shall enjoy the right to have the assistance of counsel for his defense.
In this case, the court found that the Sixth Amendment's guarantee of counsel was a fundamental right, essential to a fair trial, which should be made applicable to the states through the Due Process Clause of the 14th Amendment. Justice Hugo Black called it an obvious truth that a fair trial for a poor defendant could not be guaranteed without the assistance of counsel. Those familiar with the American system of justice, commented Black, recognize that
lawyers in criminal courts are necessities, not luxuries.
After the court's ruling in Gideon v. Wainwright, Gideon was retried with a court-appointed attorney, and with that attorney's help he was acquitted of his crime. The Supreme Court declared any and all instances where indignants were not provided lawyers as violations of due process of the law, and in that they were granted retrials retrogressively. The Supreme Court also made Gideon retroactive, applying to not only defendants that stood trial and lost, but also those who pled guilty because of a lack of due process. Defendants must now know when he or she is waiving the right to counsel, with many states actually requiring waivers to decline counsel. Gideon v. Wainwright led to the expansion of the public defender system and led to their extension to all of the circuit courts of each state, as well as more extensive training of each defender to defend each and every possible case. Nowadays, public defense offices are swamped with new defense cases. Miami public defenders take up to 500 felony cases per year, and according to Eric Ekholm of the New York Times, up to 2,000 misdemeanor cases are on their docket at any given moment. Some critics have postulated that this massive influx of cases has actually led to a decrease in quality of defense. Gideon v. Wainwright, in defining the standards of due process as well as defendant representation, should be considered one of the key landmark cases in the United States history. As Robert F. Kennedy proclaimed, if an obscure Florida convict named Clarence Earl Gideon had not sat down in his prison cell to write a letter to the Supreme Court, the vast machinery of American law would have gone on functioning undisturbed. But Gideon did write that letter. The court did look into his case, and the whole course of American legal history has been changed.
Map was searched illegally by police officers. They entered a home in suspicion for a fugitive. The police officers did not have a search warrant during the time, yet they forced their way into her home, finding obscene materials. Mapp was arrested for violating Ohio's law that bans possession of pornography. Without the 14th Amendment, the Fourth Amendment would only apply to federal searches. However, Mapp was able to appeal to a higher court. She made it to the SCOTUS. There, the case was brought up violating the right to privacy of a citizen, along with unreasonable searches and seizures, which rendered the material useless in court. The case ended with Doherty winning with the help of selective incorporation to enhance the Fourth Amendment, which again made the materials unable to be used in court. Selective incorporation actually allows Bill of Rights to apply to the states along with the federal government. Selective incorporation is part of the Due Process Law, which is enhanced by the 14th Amendment. Thanks to the Bill of Rights, not only protecting us from the federal, but the states as well, we are able to maintain our privacy and freedom for both states and federal.
Before the Miranda decision, criminals and suspects were given few rights and were often presumed to be guilty. They were rarely informed of their rights upon arrest, and some were even beaten and held at gunpoint by police during an interrogation. However, in 1966, Ernesto Miranda appealed to his case to the Supreme Court on the grounds that he had not been informed of his rights upon their arrest. The decision in his favor led to the development of the Miranda warning. This legal revolution has triggered significant reforms in the care and the treatment of the accused. The Miranda warning is intended to protect the suspect's Fifth Amendment right to refuse to answer self-incriminating questions and their Sixth Amendment right to the assistance of an attorney. This court case has reformed the justice system upon arrest and interrogation, has stimulated the public reaction that the Miranda warning has given criminals and suspects rights they do not deserve, and has revolutionized the treatment of criminals. The revolution of criminals' rights all started with the assault of a young woman. One day, walking home from work, a man by the name of Ernesto Miranda grabbed her and proceeded to rape her. This criminal act was the beginning to a case that would be made famous worldwide. Miranda was brought to the station for interrogation. However, authorities withheld all information from him. Miranda was never told his Fifth or Sixth Amendment rights. This was a key factor that would change the entire theme of the case against him. Earl Warren was the Supreme Court Justice at this time. What resulted from this case were the Miranda rights, which is what follows. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be appointed for you. It has revolutionized the treatment of criminals. Without this case, criminals' Fifth and Sixth Amendment rights would not be clear, and the treatment of criminals would not be fair. This case has revolutionized modern interrogation and casework.
An important figure in these cases is Chief Justice Earl Warren. President Dwight Eisenhower nominated Earl Warren and then was sworn in on Monday, October 5, 1959. Along with his Supreme Court term, they named the period the Warren Court until he retired in 1969. He was suspected of being a conservative, but to Eisenhower's infortune, Warren was an abashed liberal. His main focus was on civil laws and civil rights. In Gideon versus Gainwright, Matt versus Ohio, and Miranda versus Arizona, Earl Warren voted for these cases. His vision of equality brought his connection to these cases. Actually, Earl Warren ended up writing the majority opinion for Miranda versus Arizona case.